Right, thank you everyone. So we've heard a lot this morning about the potential reforms to dispute resolution services and public justice systems and what that might mean for judges. So now is our chance to actually hear from judges about the likely implications for their practice. So without further ado, I'd like to hand over to His Honour Judge John Aitken, who's President of the Social Entitlement Chamber. And you're mic'd up, so you don't need this.
Good afternoon. 25 years ago, I went to see Billy Connolly. I think he's sufficiently worldwide known for you to understand. I went to a concert. It was a great night, absolutely fantastic concert. Laughed the whole time. Can't remember a word he said, despite the fact that in the middle, he explained that he was now going to tell a joke just so that when the next morning people said to you, how was the Billy Connolly concert, you could say, oh, I can remember a joke. He said, because otherwise they'll ask you and you won't be able to say it. And I've forgotten the joke as well, I'm afraid. I remember one thing he said. And the thing he said was, well, what he described was why he became a folk singer, because he was a folk singer before he was a comedian. And he explained that in the, I suppose it would be the 70s then, he went to a lot of parties in Scotland, and he said they all followed the same format. Everybody got a bit to drink, just a little. And then someone would do a turn. They would get up and they would sing Flower of Scotland or something, and you had to do a turn. It was obligatory. If you turned up and went to the party and drank their booze, you must do a turn. You must sing, play a musical instrument, or you must perhaps read poetry, something like that. And he said that he became a folk singer, he said in part because he'd seen what happened when somebody sang your turn. They sang your song and you hadn't. And you had nowhere to go. You had to produce something, and you had to you had to be ill, and you had to leave. And he explained that that's what you had to do. That's how it was. Yesterday, Susan Ackland-Hood used all my slides. Right, but here you get a chance to look at them again. The core expectation of reform, as I understand it, and understood it at the start, was that the reform system would work better for all of those involved. It was inclusive in that way. It was not something driven simply to say, we'll make it cheaper, we'll make it better for the public. It was better for everyone. It was the call to arms, if you like, by Lord Thomas, the then Lord Chief Justice, was to look at a system. It worked better on a sort of numerative alliteration then, because I think it was 2014 he was saying it, or 2015 perhaps. It was a system not fit for 2015, fit for 2050. That we were to look ahead and really put it together, and what could we come up with? And so in SSCS, the Social Security Child Support Tribunal, where we deal with benefit appeals, up to $600,000 a year on a I don't want to say a bad year, although it was a difficult year that. I fortunately wasn't the president then, that was someone else's problem. But we run on about $250,000, I think the forecast is for about 300,000 next year, and about $250,000 is standard if you look back over our entire history. So quite a large tribunal. Our most popular appeals are personal independence payments, where we have a 3-person panel. And they're a growing and larger proportion. So although our numbers are staying fairly stable, the complexity of the cases and the number of people that we have to schedule and list in is growing, arguably 2 or 3 times because of the number of people. So we looked at the situation and we put forward a paper which looked at an online system. And I've been really heartened to see that many of the items of research, we looked at some research first, but many of the items of research which I've seen since seem to indicate that we have got the direction and had got the direction right, and we're deeply involved in that process now. The cornerstone of that paper was the concept that if an appellant, and indeed the respondent, and there are reasons why the respondent isn't sometimes terribly involved in our system, had the opportunity to communicate with each other and with the judge from the outset, or the panel, when I talk about PIP, they'd be confident enough to accept a fully online decision. And some of the research seems to indicate that that's probably right. It was a little speculative then, but it does seem to be the way things have moved and are still moving. We did have some indicators that it would work. It wasn't all blue sky thinking. We looked at the Traffic Penalty Tribunal. The significance of them being that they installed an online case management system. That's what it was intended to be, as I understand it. Well, they installed a database to begin with, and as part of that, the developer, and Caroline Shepherd, the president there, tells me that he, as a sort of side remark, said, look, I've got this interactive chat thing that you can have added to it. Why don't you try that? And she thought, well, that'd be a good idea for case management. So they clamped that onto the side, if you like. They started using it, and what they found was that when people were in contact with the adjudicator, because they're not part of the tribunal system, we call them adjudicators, when they were in contact with them and the adjudicator would identify either problems or further evidence or whatever from either side, that what happened next was when they got to the end of that process and everything's sorted out, right, okay, we've got this photograph, we've got, you know, whatever the evidence is. Once they did that, the adjudicator would say, right, now we're ready to list your oral hearing. People started to say, well, why do I need an oral hearing now? You've got all the information. You know what the case is about. Can you not just deal with it? And it led to a position where she was finding that 85% of people who had asked for an oral hearing, because of course they could have just had a paper disposition to start with, 85% of those people changed their minds and said they now wanted it just dealt with by the adjudicator there and then. So enormous potential there for speed and efficiency and satisfaction. And she has very high user satisfaction rates, very similar to the ones we've seen in British Columbia. So we saw that, and inspired by that, we thought we could apply that sort of logic and process to what we do. And we also had the benefit of some research by Hazel, which had looked at whether it was better for an appellant to have a paper decision or an oral decision. There was always a sort of legend, if you like, or a feeling that it was better to have an oral decision, but Hazel would look at it properly and get the numbers. And it was that. It was better to have an oral decision, basically. And she did it with using the shadow tribunals, and in short, what happened was that you had a large chance of winning if you were in an oral hearing and a lower chance of winning if you were in a paper hearing. But if another panel had the information that was gleaned at the oral hearing, then it became very close to the same result as the oral hearing. So it seemed to be information-driven, not simply attendance, which reinforced our feeling that if we had interaction online in the same way as the Traffic Penalty Tribunal, we could produce fair, quicker and more accessible appeals to our appellants. And so the system that we conceived that may well look very much like British Columbia. But the idea was, or the idea still is, that it will not be one that diverts people. I know Judith will be pleased to hear that. It's not one intended to divert, because we work from the belief or the feeling that mediation, that early neutral evaluation, that any conciliation, any of those things are really substitutes in our jurisdiction. There are different jurisdictions doing different types of work, but in our jurisdiction we considered that most of that was really to deal with deficiencies in our process, because we weren't sufficiently quickly engaged, we weren't sufficiently efficient, and it was a substitute for the judicial involvement. And what we felt was if we put the judge in straight away and had what we would call a continuous online hearing, that people would be better served. They would have a judge dealing with their case from the outset, at stages at the beginning which would look very much like case management, but which would stay with the judge until they were given a choice, and we felt they should always have a choice over how they wanted the hearing dealt with, and that subsequently we would probably get to the same levels of trust that the Traffic Penalty Tribunal were exhibiting, and that most people would say, you understand the case, you know what the case is about, deal with it. So that's what we started planning and building, and that's some of the slides. I don't think you saw this one from Susan. I was quite pleased with this one because it's a bit simpler than the slides you have seen, because they appear to me to be pretty cluttered. But we're looking at, wherever possible, simple input. You get relevant information, but that's a bit crowded. This you did see. And that, we have to do something about that, I think. That's just too much. Great if you're used to it, but not otherwise. And informative, interactive summaries, you can click on things. But again, we need to simplify. Those are the ones you've seen from Susan. That you've seen is presently what is going live in the next few weeks. This is the way that the judge will interact with the appellant to begin with. You'll see that what the judge composes some questions or composite questions, and the form is filled in, if you like, that box, with a reminder and a time limit. I feel, and I need some evidence, which is obviously why I'm here, we need some evidence that that's the best way of getting people engaged in the process. I very much doubt it. The concept that we originally had was that it would be as simple as something like WhatsApp or something like that. Open to misinterpretation sometimes, so one has to be careful. I can see that. So we do have to be careful about that type of exchange, and we do very much understand that. And it'll be somewhere in between. And I've heard some fantastic ideas here about putting a video on. So why don't we, as an idea, at the start of a text-based exchange, have a short video of the judge explaining that they'll be dealing with the case in order to familiarise the person with how it'll work eventually. I suppose if we're dealing with younger people, we're often not, but if we were dealing with younger people, the video would be much more useful. I know my children, and I've started to try, and I've started to teach judges to use YouTube and to look things up rather than just using Google. Get pictures, watch a video of somebody finding a file on your computer if you can't find it, stuff like that. So we have a number of people we've got to persuade that this is the best way ahead. We've got the public, and we think we'll do that by offering them a better way of dealing with the problem, more convenient, but still we think a rigorous examination of the situation. And we intend to do that by choice, by enabling them to make a choice of how do they want an oral hearing, or are they happy with this way of dealing with it. There's a perception that the paper consideration may lack some of the evidence, and so that's of course supported by the research. So we want to make sure that people understand that this is a different and more interactive system. So we've got to persuade them of that. And we need to also include representatives. Representatives, we hope, will be able to represent more. It's expensive in terms of time and money to have a representative. Quite often the Department of Work and Pensions, who are the respondents in our claims, don't have anyone attend. And most appellants are unaccompanied as well. I've spoken to organisations, some free representation units and some citizens' advice bureaus, the hope being that if you can interact asynchronously like this, that what you can do is have a consultation where you may be given advice, and at the same time you're able to go online and put the point forward that you're told that the appellant wants to put forward. And there doesn't seem to me to be any reason why that couldn't be included in the conversation, in the same way as you'd be making a submission if you had attended. And so we can compress the time that representative might need to effectively input in the case. So, and the organisation that I've spoken to are enthusiastic about that. The Department of Work and Pensions, one of the, it used to be a statutory role of mine, or this office, to provide a report on how well they were doing, a sort of end-of-term report each year on how well they were making decisions. And over 60% at the moment are going the appellant's way. So, yeah, I suppose there is an argument to say 50%. It could be 50% if you were right on the border and you were dealing with things. But this system, if we can get the decision maker rather than a representative from the Department of Work and Pensions into this, they complete the feedback circle, if you like, because they don't have to leave the office. It should appear on their computer. They can see what the appellant has said, because the problem the department has at the moment, they will explain to you, is that any time a decision is found against them, almost certainly the judge has heard some oral evidence, has heard some extra material that they haven't had access to. And so how could they be expected to make the same decision? And it's not a bad defense. But it evaporates completely with this, because they would see every word that the judge has seen and have an opportunity to comment in just the same way. We've got to find out how much time this will take and how we will organise it. Lots of things to be moving on with. But we think there's a sort of complete circle of feedback there, a perfect feedback loop, we think. One of the worries, of course, is that it might be too easy to appeal, that every decision would be appealed. But I think that's doubtful. And if the feedback loop is as good as I hope, and if the decisions are as good as they should be, then why would you appeal if it appears to be the right decision? Well, we'll have to deal with that sometime in the future, perhaps. But for judges, a short story about whether judges like working at home. I was the regional judge, I mean, who doesn't, but I'll tell you the story anyway. I was the regional judge at North Shields, there are, I think, 7 or 8 asylum and immigration centres around the country. So I was the regional judge for the northeast at North Shields. And it was the smallest centre in the country. And we had things called visit visa cases. There would be 22, and there were people who were coming to visit their relatives in the United Kingdom, and the entry officer, the immigration officer, had refused. They said, no, you can't come. And they would appeal. And so we would deal with it. 22, and a judge's list was 22 over 2 days, so 11 a day, and they would write a couple of pages explaining whether it had been allowed or refused. And the standard rule was that you would come into the centre, you would sit and do the first day's work in the centre, but then you could take the rest of the files that you hadn't completed back to work at home on the second day and send them in. And we changed the rule, and we said, you just work at home. If you just do them properly, in time, just do that. There was a little bit of resistance at first, because there were worries that someone would go sick and we wouldn't have a spare judge, because we would have several of these judges around, we could just move them into place. But judges don't often go sick, is the truth. Very low sickness rate in judges, about 2%, something like that. And I understand last year no presidents were sick at all. Go figure. And so what happened was that it became very popular. And then we started having to send to other centres and say, have you got any visit visa cases? We've got a list to make up, and we just haven't got enough. And then we started bringing it in by the truckload. And then we started getting judges from Scotland, particularly. That was the particular area. They often sat in Hatton Cross at London, and they found it easier to travel from Glasgow, which was another fairly small centre. They would fly down to Hatton Cross, do a day's work, and fly back. And that was quicker than coming to North Shields, because it was a 4-hour drive or a 45-minute flight. It cost a lot more, but that's what they would do. And we would pay their travel expense. So then the judges from Scotland started saying, well, can we not work at home on your papers? And so we got some more work in. Truckloads of work was coming from Hatton Cross, out of their cupboards. They couldn't get judges to come down. They were sending a truckload of work to us, and we would put it into packets and send it out to judges. And they would do it all and send it back to us, and then we would file it. And then I got stopped, or there was an attempt to stop me doing this, because the postal budget had gone crazy. And so I remember having a surreal conversation with someone from HMCTS, and they're saying, you've spent all our postal budget for the year, these files going back and forward, you can't send any more out. I said, you're kidding me. I said, how much does it cost? And they said, £30. I said, how much does it cost to have somebody drive down here, keep them overnight in a hotel, because it's 4 hours drive, keep them overnight in a hotel, pay them to go back again, and then pay for the postage anyway for half of it, because it's got to be posted back? Well, £400. I said, well, you know, what? Explain this one to me. £30, £400, which one do you... Oh, they said, we don't pay the travel budget. We only pay the postal budget. I said, okay, who runs both budgets? We found out who runs both budgets, and we said, what would you like us to do? And would you believe we kept on posting, and they kept on trucking the files up, and then eventually, in fact, all centres started allowing judges to work at home, and that was the end of it. So they do want to work at home. They work on computers, they do banking, they do all sorts. IT skills, I think they can pick up on YouTube, as I've indicated. I've advocated. No, seriously. It doesn't sound seriously. But what you do, I think, and I've spoken to our training lead, and said, look, it's no good putting people in a room like this and saying, right, this is Word, all right? You press File, Open. It's just hopeless. You can't do that. But what you can do is you can say, this is YouTube. You type in there what you want to know, and some 18-year-old from Minnesota will come on and say, press File, press Open. Everything is on there, and everything has a video, and everything is easy. You just need to learn how to access it. So we just need to give these people nets, not a couple of fish, to keep them going. So we think, and my next problem is payment. Paying a judge by a case is piecework, and that feels uncomfortable. But we sort of do that at the moment. We bundle those 22 visit visa cases up over 2 days, and that didn't feel uncomfortable. So we need to find a way of making that feel properly comfortable so that we can encourage them to work hard, but not encourage them to cut corners. But what you must remember, of course, is everything can be appealed. And if it's a system like this and it goes to the upper tribunal, it's just a case of pressing the button and the upper tribunal seeing every word that was written about the case. So instead of someone saying to the upper tribunal, do you know, they rushed through my case and because they wanted to get away, and the upper tribunal said, well, you say that, but they seem to have written a nice judgment. It seems all right. Here, they'll see exactly what's written down. One last thing. I did see on the British Columbia website that there was a line with a button on the bottom saying, if you don't like this form, press here and tell us why. I am definitely going to have one of those. And we're going to start this in a couple of months. Okay, thank you.
Thank you so much, John. That was really interesting. And I think one point that you raised there, which was really interesting, was about the potential for these reforms, at least in the early stage, to put increased pressure on the advice sector in order to support people to navigate them. And we know that we have a fairly decimated advice sector in the UK following legal aid cuts. And I think, Shannon, if I'm correct, the Civil Resolution Tribunal, you've worked really strongly in partnership with the advice sector and legal experts in helping them to help support people to use your systems.
Absolutely.
So without further ado, I will hand back over to Shannon to talk about her experience.
So I have to issue a disclaimer that despite this initial slide, what I'm about to say over the next 20 minutes is my own personal perspective. Is it not? Oh, there we go. Thank you. Is my own personal perspective. I'm not speaking as chair of the tribunal, but these are my kind of off-the-record observations about where I think the future of the profession and the judiciary are going in light of some of these reforms and some of the demand for evolution that I see happening over the next few years. So again, not going to go through the slide again, but just to refresh your memory, most of the disputes in our system are not resolved by humans. And I think that's a scary point for both judges and for lawyers. So remember, the first stage is this artificial intelligence question and answer service that now over 40,000 people have gone through. And while the data and the content was created by lawyers, volunteer lawyers, no lawyers are making money off that legal information portal. But this is information that people couldn't afford to get from lawyers in any event. But what it shows us, I think, is the nature of legal information and legal services will change, because our system is a very nascent version of something called an expert system, which uses something called knowledge engineering to provide legal information to the public. Knowledge engineering is a skill that I think lawyers are going to have to develop over the coming years. And it's one of the reasons that knowledge engineering is starting to become a course offered in law school. How do we take information that used to be the exclusive domain of lawyers because they had to find it in dusty old leather-bound books in the bowels of a library or a law office? Now all of that information, like medical information, is readily available online, but there's still not a really great way to distill it, especially in common law jurisdictions where a lot of this law is judge-made. And how are you meant to know from reading 100 cases even what the law really is? So expert systems allow us to synthesize this information, but it does mean that the kind of information and the kind of skills people will be asking from lawyers is going to change. Similarly, the second stage there, no humans either. This is just connecting people using technology to talk together. And between those two first phases, the vast majority of disputes are resolved. Again, no humans, no judges, no lawyers. And again, I know that you saw this slide yesterday, but just also to refresh your memory, when we go to people and we ask them what they want in terms of the civil justice system, they don't talk about judges and they don't talk about lawyers. They talk about being able to solve their problems with assistance, with support, with help. But 87% don't want full legal representation. 94% don't want a lawyer or a judge like me telling them what the outcome will be. So in this context, and in combination with the technology, which isn't working particularly well for me right now, we have to ask ourselves, what does this mean for what judges and lawyers are going to be called upon to do? This is a screenshot from a presentation that I did for the ABA, the American Bar Association, a couple of months ago in Vancouver. And I made some off-the-cuff comments in the course of the presentation that I stand by, but which seem harsher now that I see them in black and white, because there was a journalist for the ABA website in the room, and this is what I said. I was asked about what ODR means for lawyers. And so what I said is, my response to that concern, and I said as a lawyer, is that society doesn't owe you a living. If you make your living because justice processes haven't changed since William the Conqueror, and they're still Byzantine and they're still complex, and you happen to know how to navigate them, then that's not an interest that society should protect. So if we simplify processes and we take away your work, then you need to find different work. And this sounds common sense, I think, and I stand by it, even though it does sound harsher in black and white. But we are not owed a living as lawyers, and that is not something that's expressly said often in groups of lawyers to me, but it's certainly the subtext of what a lot of what is said. That if ODR changes the nature of legal work, then what will happen to the lawyers? That things should stay the same because otherwise what role will lawyers have in our society? And I think they're lost in that is the public and the public interest, and the fact that as lawyers, we provide a service. Certainly we're officers of the court and we are the custodians of the administration of justice. We have this public role. But when we're charging hundreds of pounds an hour, we better make sure that there's a value proposition there. And if we can streamline the way that we provide legal services to the public through public bodies like tribunals and courts, then I'm sorry, but lawyers have to adapt. And it is a degree of hubris we have as a profession to think that our industry, which has refused to change for hundreds of years and is protected by a monopoly through professional regulation, should never be disrupted the way that pretty much every other single industry in the world has been disrupted over the last decades. We've had an extended period of non-disruption because of the protectionist nature, some would even say a cartel, that limits other people's ability to do certain things in the common law world. But I don't think that excuses us from having to evolve. And so that's the risk. The risk is that the services that we offer, a lot of them exist because existing processes are too complex, too expensive, too confusing, and people can't figure it out on their own. So you take away that complexity, you take away that delay, you take away the confusion. How do lawyers adapt? Here are some of my suggestions. Figure out what your value proposition is as a lawyer. Do you exist? Do you make money because of that complexity and delay? Well, that's going to be a time-limited service, because as we evolve, those needs will decrease. If you make money as a lawyer because you offer sound judgment, clear communication, because people can understand in a predictable way what it is you offer and what it is you're going to do for them, then I think that that's something that will endure if you also adapt to some of these other skills as well. And part of that value proposition going forward, I think, is learning how, for most of us, to unbundle our services so that we can offer services not just to the 5% at the top who can afford them, or the 5% at the bottom who get access to legal aid, but what's called the missing middle, that 90% in the middle who can pay something, but not a full ride retainer. And so one thing that we're hearing about from lawyers in the who are using the CRT or offering services in the CRT is that there's an opportunity, especially for more junior lawyers, to make money in providing these services, and it didn't exist before we existed. So whereas somebody won't pay $5,000 to get advice on a small claims matter, they may well pay $300 or $400 to sit down with you for half an hour or to get some tips on mediation. And they may pay another $500 for you to spend an hour with them, helping them structure their arguments a little bit. But that requires us to really rethink the way that we provide legal services. And I say this to my law students too. It's hard to think of any other profession or any other service where you tell your clients, yeah, you can hire me, but I can't tell you how long it'll take. I can't tell you what you'll get at the end of it. I can't tell you when it'll be done or how much it will cost. And I can't tell you really the risk to you in terms of any of those things with any degree of precision. So unbundling your services provides certainty to people, but it also opens up radically new areas of service, untapped markets, if you will. Learning technology skills, and I don't mean this again in a hacking elections coding kind of way necessarily. There's a lot of discussion about whether lawyers need to basically be data scientists, and I don't think that they do. But I also think that to adapt to these reforms, you do have to have a basic understanding and comfort with the kinds of skills that, as Don said, you can YouTube about. How do you upload evidence, because it's going to be uploaded in the future? How do you use email and office systems to communicate with your clients that work on their schedule as opposed to your office hours? Another way that lawyers, I think, can really adapt is to help lead the justice transformation instead of sitting on the sidelines and just actively resisting any change at all. And of course, this is a broad generalization because a lot of lawyers are actively involved, and certainly the ones in this room are, because that's why you're here. But I think to the extent that we can shift our mindset as a profession away from resisting change and increasing protectionism towards rolling up our sleeves and creating the justice system that we want to see for people, not only is that better for the future of our practice, but that means that we can actually shape what this might look like in the future. And a bunch of us can actually get work out of it as well, because it's a big job. And then last but not least, and this also ties to regulation, at least in Canada, multidisciplinary teams with lawyers as part of them are a problematic thing from a regulatory perspective. It's difficult. I know that you've had experiments with alternative business structures, which is a move, I think, away from that to a degree. We haven't done that so much in Canada. And what's more, it's very difficult to structure a full service practice where somebody who has a family problem can also get the credit counseling that they need, the emotional counseling that they need, and the other services that they need as well. So I think the silo approach to providing legal services is pretty much dead, and it's hard to think of any other industry that hasn't embraced multidisciplinary approaches. And if you want to see an example of that, all you have to do is look at the big accounting firms and the variety of services that they now include, including legal services, but also business transformation, and also accounting, and also management. We need to move in that direction. So that's really in a nutshell. I could go on about that all day. But what about the judges? So what about the work that all of us do every day? What are the risks? Well, we've heard, I think, some of that already talked about in this conference. And I wrote a paper a little while ago where I kind of went off on a bit of a rant about what I called the alternativization of the public justice system, where I go to conference after conference and I'm often the only panel member who represents the public justice system, anything in technology happening in the public system. And the other panel members are often ODR providers or startups that provide dispute resolution services in a private context. And then contrast that with the other kinds of panels I sit on, which are more like this one, where we're talking about the public justice system. But the conversations in those two groups are very, very different. And what worries me is that when I'm in rooms like this one, but not this one's far more, I think, open-minded to change than a lot of the rooms full of judges and lawyers I sit in, what the debates center on there is whether transformation should happen, not how it should happen. And it reminds me a bit of rearranging the deck chairs on the Titanic, because then the next day when I'm on the tech panel, what I see are all these startups talking about market segmentation and market share and who they're targeting. And they are free to target people who have a middle-class education, a middle income with a particular dispute type. And while we see case volumes decreasing year after year in the public justice system, we see increasing alternatives in the private system that are great, but they are unfettered by the obligation that we have as public actors to address the needs of everybody. I can't pick my market segment with the Civil Resolution Tribunal. That's why I spend so much time on inclusivity and working with advocates. And what I worry about is that while we debate publicly whether this should even happen, people are voting with their feet increasingly year after year. And where does that leave the people who do not fit into any of those market segments? We heard a discussion about the rule of law. Where does ODR fit in with the rule of law? Well, let me ask you this. Where do private systems fit in with the rule of law? Private systems have no obligation to safeguard the rule of law. They have an obligation to adhere to the regulatory environment and the legal environment that they operate within, but they are not custodians of the administration of justice the way we are. And so I think that's a powerful argument for why we need to take on this modernization project or risk obsolescence, not just as judges, but as the judicial system publicly more generally. So that's my pitch for what the risk is. The risk is obsolescence, in my view. And it's quietly happening year after year as those trials go down in almost every common law jurisdiction I visit. So the other risk, technology gap. We have in many jurisdictions I visit, and Canada is no exception, a pretty monolithic bench despite increasing attempts at diversity. And part of what that means is that we have, as a generalization, a judiciary that doesn't feel terribly comfortable with technology for the most part, some of whom don't even use email, are deeply skeptical of anything to do with technology, in part because they don't always understand it. And I think that's a risk not only because it means that there's a real incentive not to change anything, but it also creates a distance between the judiciary and the realities of modern life and the context in which the people who appear before us operate. So how can we adapt as judges and tribunal members and courts? Again, I think the key is leading the change. And I point to England and Wales as an example of this, where Lord Justice Briggs, as he then was, and the judiciary was really the impetus for some of the change that has now, of course, been taken on by the ministry and by the courts and tribunal service. But by leading the change, we can make sure that some of the key ethical questions that we've been talking about this weekend are addressed. If we continue to stick our head in the sand, then we are essentially accelerating this alternativization of the justice system. Putting ourselves in the public's shoes. I promise 5 minutes will do it. I'll just talk faster. But when we put ourselves in the public's shoes, we can really, I think it really transforms the way we see a justice system, and it doesn't require technology to do this. So when I was speaking to a room full of judges in Ukraine, with courts that sometimes still use ledgers, never mind computers, what my pitch to them was that you don't need to wait until you have perfect technology or ODR systems to do this work. All you have to do is take a clipboard with your form, leave your chambers, walk into the court registry line and start talking to people. And I mean that literally, talking to them about what their journey was there today, that day, in the life of their claim, what their circumstances are, what have they found most confusing, how did they even know which desk to go to? And taking all of that information, asking them to fill in forms while they're standing in line to test things, to do that A/B testing. You can do all of that with no technology at all. And it really shapes the way that we can lead that transformation while still respecting the rule of law, while holding on to those foundational legal principles that we all care about a lot. Some of the other things I wanted to briefly mention in terms of adaptation are really skills-based. Some of this is cultural and attitudinal, but there is a skill shift that I think has to happen in common law countries in the future. And these are a lot of skills that we train our tribunal members in, partly because they, I think, are necessary to provide proper justice in a modern context, but also to adapt to the vagaries of online dispute resolution. So all of our tribunal members go through training in implicit bias. I actually make them do the Harvard implicit bias test. I don't know how many of you have heard of that, but it's a free online test you can do on a whole variety of different factors. They do a plain language boot camp, and we run sometimes their decisions through an e-reader, that electronic reader that will tell you what the reading level is of the decision. So then you can revise it and write it down again. Cultural competency training, they all have mental health training, so they know how to appropriately communicate with people with mental health issues. 1 in 4 Canadians do have a mental health issue, and I'd be surprised if the stats were significantly different here or in the US either. We teach them how to communicate empathetically while still being neutral. And this is, of course, important in person, but when you're doing it at a distance, you lose some of those visual cues that can help communicate empathy. But you can communicate empathy in different ways, in the way that you write, in the way that our staff communicate, but it is also important for tribunal members. We teach them active case management. So at least in Canada, the common law approach to judging is very hands-off. The idea is that the judge is the recipient of the evidence and submissions that the parties bring to them. They are the recipient of the record. They are the recipient of the parties' timelines, of their estimates, of their witness counts. And with increasing self-representation and a need for more efficiency and to decrease delay, judges, I think, in the future, and certainly our tribunal members, have to roll up their sleeves and do a lot more active case management, set deadlines, hold to those deadlines, move the cases along so that parties don't languish for years and years without a decision. And part of that, too, is getting more actively involved in what evidence and submissions you get from the parties. And this is an uncomfortable inquisitorial thing for a lot of common law judges and even tribunal members. Tribunals tend to be more inquisitorial or hybrid, but this is something judges are increasingly talking about having to do, and it's uncomfortable for them. But my view is that it's necessary, because often what happens for us in cases is that the parties, the issue I have to decide is here, and the evidence and submissions from the parties is all over here. So I have 2 choices. I can say that the applicant has not met the burden of proof that they're required to and dismiss their case, or I can go back and say, the issue I have to decide is X. Do you have any evidence on X? Do you have any submissions about X? And give the parties a chance to respond. And that's usually what I do depending on how significant the claim is. If we have more than half of the people who appear in our civil courts are self-represented, then my position is no different from that of a judge in a superior court who's faced with the same dilemma. And in my view, fairness, procedural fairness with lay people requires us also providing some information. It requires us to be more inquisitorial in the future. So that's my pitch for change, I guess. And I think I've stuck, more or less, right to the minutes. So there you go. And there's my infamous stick.
Shannon, that was really, really interesting.
It just pulls apart, yeah.
You've got the other one, right?
Good. So next up, we're going to hear from Dory.
So Hazel, really, I may have forgotten to thank you yesterday for the opportunity to speak here. And really, after all this, I couldn't thank you enough for having allowed me to be here, because I have heard so much that I could talk about for hours, but I don't have time. So what I'll do now, like Shannon, this is my personal take on what I think right now are the most important issues that I see in the debate. So it's my personal view, it's what I wrote down 2 weeks ago before I started traveling. And I hope I can remember all I thought about then, because I have learned so much in the meantime that I'm not sure I won't get it confused. But let's see where we go. Some themes about judiciaries and courts. I already said yesterday that one of the issues is that access to justice is often regarded as part of a market. We talk about digital access, and we see that the way especially digital applications are being developed as a sort of a way of marketing dispute resolution. The second thing I'd like to talk to you about is digital access a little more in detail. Then what I see as an emerging trend is legal design thinking. And what does all this mean? Where do the courts find themselves in the world? And finally, a little more observation about the transition from network to system technology, something I already addressed a little bit yesterday, And I may not even have time to do it today, but then you will remember what I said about that yesterday. So, question, is access to justice a market? And in a sense, of course, it is, because there are all sorts of tools out there that help people with problems that might have ended up in courts had they not used those tools. One of the problems that I find with those tools is that they are being developed, but how do people find them? I mean, I developed a tool for my court system, lovely tool. It wasn't used much, and why not? Because it was 3 levels deep on the judiciary's website. And a couple of other reasons that I won't go into now, but people could not find it. So I had a discussion with a friend of mine from Turkey who works in ADR about this, and I said, you know, how are we going to solve the problem that people have to be able to find the tools we develop for them? And she has done research on dispute resolution in the Grand Bazaar in Istanbul, talked to the shopkeepers there, and they have their own system. And she said, from that, my conclusion is that you have to put the solution as close to the problem as possible. So where the problems arise, that's where the solution should be. And that, I think, should add another layer to Richard's triangle, the upside-down triangle he showed us yesterday, that starts with accessing the online court and first doing an evaluation. There is a layer on top of that, and that is the layer that's actually maybe in the market, outside of the public sphere, but nevertheless there. And the second answer, of course, to the question whether access to justice is a market is no, because it's a citizen's right to have legal protection. So what does that mean, if anything? I'm going to leave that question hanging in the air here. Legal design thinking. It's something that I've become acquainted with over the past 2 or 3 years, and I think it's a very interesting and different way of looking at justice procedures. When we designed the new procedures in the Netherlands, we use an agile product development methodology, and the first thing you learn there is that the most important person in the process is actually the user. And so I was struck by how Lady Hale explained last night that when she uses pseudonyms in court decisions, she actually consults the party involved about whether they would like that. And I think that is, generally speaking, the way that we should go. The users are the most important people in the process, because if they can't handle it, then it's ineffective. And legal design thinking is a very rigorous methodology to actually think about your users. One tool that we use, and that is generally used in legal design thinking, is persona. That is, I design for instance, a 45-year-old woman with 3 children who doesn't like this, who has a dog, and things like that, in order to imagine the person who is going to be actually use your tool. And you're not only making it for 43-year-old women, but for other people as well. So we have a whole range of personas that we design for. And of course, we also do user testing from day one, but that goes without saying. The other phenomenon that really fascinates me is legal hackathons. Hackathons are concentrated events where teams devise solutions to problems that usually they are allowed to think of themselves. I've seen a couple of very interesting ones, one in Estonia, a couple in the US, at Stanford University, where Margaret Hagan does a lot of interesting work there. But actually, designing the tools is the easy part, because the hard part is to make sure the solution is where people have the problem. So much about legal design thinking. There's a lot more. So the hard part is, where are they? Let me see what I still missed out on this one. And actually I could even skip the last one, but on the next slide, I found this has been so insightful for all of my work, that keep in mind, people do not have a legal problem, and people are not a case. They are someone with a problem. And Hazel's research has taught me the kind of information needs that people have depending on where they are in the process. And the process is not linear. If I skip this one, I'm sure you will know all that. Courts are not part of, I mean, some of the innovative thinking is that courts are part of a chain, but they're not really part of a chain, they're part of a cloud. Because if I have a problem, I will start looking for solutions, and that can go anywhere. It doesn't go just in one direction. So courts are part of a cloud, and they better start behaving like they are part of a cloud. People go back and forth looking for help. What else? One of my principles has been to try and learn from private online dispute resolution, because I think that can be very useful if you're designing court systems. But keep in mind that usually ODR systems, like for instance the eBay negotiation system, they're one-trick ponies. They can do one thing very well, but they can't do anything else. And my problem when I had to design the system for the courts is that my pony has to know a lot of tricks beyond the one that is already there. On the other hand, I think, but I'm not sure that anyone has ever tried that we should maybe try and design one-trick ponies, and a lot of them, instead of trying to replicate the old court system. But I'd love to hear if someone has actually tried to do that. I haven't seen it so far. So the question is, should we replicate court processes? And the answer to those, of course, is yes and no. No, because then we're not really leveraging the power of information technology. And yes, because we have this whole court organization that has to familiarize itself with a new way of working, and you don't want to make that too dramatic, because it will be very hard for them to bear. So that is a consideration. Try and to stay at least to a certain extent close to what people are used to in the courts. Now, I think this is my last one. Values change as we go more digital is something that I've learned from someone who teaches somewhere here in London. And one of the concepts is consistency. We had a lot of discussion about consistency this morning. And one of my observations is that there is a constant demand for consistency, but it conflicts with judicial discretion. And judicial discretion is necessary for judges to be effective. Why? Because, as we also heard this morning, people want to have voice. They want to have an influence. They want to feel they have influence on the outcome of the procedure, and that means they want to talk to their judge, and their judge should pay attention to what happened, what did that mean for you. That's the kind of debate that we have, and those are, so the voice and the consistency values are in a way in conflict with each other. And there's going to be more conflict when artificial intelligence tools are going to say they predict court outcomes. Now, I could talk about prediction for a long time. I won't do that. But it will mean that the pressure of judges on judges concerning consistency is going to increase. The other one is transparency. What about artificial intelligence? Is it, does it mean that we're going to use tools that are not transparent and then say, oh, well, this is what the tool says, so here you are? So some, I think, dramatically new issues for judiciaries to not only think about, but also to act on. And let me check if this was really my last slide, because I'm not sure. Ah, yes, here comes the artificial intelligence. 2 minutes on artificial intelligence? Okay, 1 minute, good. What I've written a small advice for the Parliament in the Netherlands at their request about artificial intelligence in the legal sphere, and what I've tried to do is to try to find proven artificial intelligence technology that would be useful for courts. I thought that would be more practical than talk about how difficult and to understand artificial intelligence in general is. So what I found is that there are some proven examples of AI that will structure information. Now, a lot of my colleagues use large case files, and they would be very grateful if something other than themselves would make sense out of all that information. And I think there's enough evidence to show that that would be a good application for AI in courts. Same holds, I think, for advisory. And why is that? Because the system will give you an advice, and it's up to you whether you follow it or not. And I think that's essential. Predictions, it's very interesting to see how those predictions actually come about, but they are statistical predictions about what might happen. So they have very little to do with legal reasoning. If actually you try and figure out, for instance, how the researchers who now say they can predict outcomes of cases in the European Court of Human Rights, if you read about their methodology, it's about the only description worldwide that I know where you can actually understand what it does. It's just statistics. And the material they use is mostly court decisions, which are enormous reductions of complexity in the material before the analysis actually even starts. So it's much less, let's say, revolutionary than you might think. Last one, if we want to take Article 6 of the European Convention on Human Rights on fair trial seriously, we have to worry about how algorithms find their output, because we need to reason our decisions, and so should the algorithms. And I think that would be a good point to stop. I wonder if this was our answer. Okay.
I rather think that sums up the judiciary, doesn't it? There's the High Court bench in an orderly queue, marching to a greater and more glorious future. The circuit bench are perhaps less sure of their approach to matters, and you'll see they're milling around. And the district bench at the bottom are marching gloriously like lambs to the slaughter. So I bring you greetings from the district bench and the coalface. I am the judicial advisor to the Civil Money Claims Project, and so my main focus is on a online civil court, which at the moment is running up to £10,000, but in the future, and debatably in the not too distant future, will go beyond that £10,000. Primarily being provided for litigants in person, and so that is the sort of area that I'm dealing with. I want to talk to you today really about where we're at the moment, looking at some of the parameters, certainly in the civil justice sphere, looking at some of the processes that the judges are going to have to get used to and become acquainted with, perhaps looking at what we want to achieve, and then looking at where research and training can take us, and I'm going to do all that in 11 minutes. So, onward and upward. Of course, at the moment, we're very much marked by the old 19th century approach. Not a lot has changed in the way in which the courts operate since a century and more ago. It's still a largely adversarial system, prepared by pleadings on both sides, where the dialectic experience hopefully brings us to an answer. And of course, in this jurisdiction, judges are drawn from the professions. And so ever since I set foot in a court of law many, many, many moons ago, that is the way I learnt how to do things. And so for me, there is some 35 ingrained years of this is how we do things. So one of the biggest problems that we are having to face now, certainly with the judiciary, is unlearning what we have learnt for our entire judicial lives. New tricks for old dogs. And I would suggest to you that even though, of course, we are modernising, we are having to take on board the changes that particularly came into being since LASPO, we're still struggling with that. In the Civil Procedure Rule Committee a couple of years ago, we began looking at how could we make the rules more accessible for litigants in person. We came up with Rule 3.1a, a very anodyne provision drafted by me, so it's my fault, which simply says that we have to take into account the fact that a party is a litigant in person in making our orders, and when we come to the trials we may have to assist the litigant in person to put questions. And there are, of course, similar provisions in the family jurisdiction. And so the sort of challenges that a new system and a new era are going to provide for us are ones which are going to come largely afresh to us all. Now, spoken by a judge for the judges, the problem as I see it is that in order to avoid spending money on lawyers, you have to be prepared to spend money on the decision makers. And I will say hearty thanks to that. Give them the right training, the right expertise. And this is the area that I really want to focus on this afternoon. This is about what training are we going to need, what experts are we going to need, and to a certain extent, what resources are we going to need. So what's the new system going to look like? Well, of course, it will be developed by the 8 reform principles that are underpinning HMCTS's approach to the matter. As far as the judges are concerned, I think the following aspects of the 8 principles are likely to define the way in which we are going to interact with the system. The first is it's user-driven. What I find remarkable and heartening is that HMCTS are building the online court from the bottom upwards. They are not digitising what we have at the moment. They go into labs, they talk to people, they test something, they find something works, something doesn't work, and the system begins to develop from the ground upwards to a point now where you can actually issue and defend proceedings online as a result of that research. And so rather than being purely judge or lawyer driven, it has the fingerprints of the litigant in person all over it. Accessible and digital by design. We've already mentioned that a lot of judges are not necessarily technologically that adept, and yet we're going to have to get used to not just tapping away on a computer in a Word process, but all the other digital tools that are available to us in order to conduct hearings remotely, as well as deal with digital files. I'm delighted to see, built upon a strong, independent and trusted judicial brand. I'm going to come back to that later on and put my head into the jaws of the lion. But before we do that, what are the parameters that we are having to work within? Well, the first is that one size will not fit all. When I listened to John earlier on, describing the processes that are underpinning his approach, they were not the same as the processes that are underpinning the Civil Money Claims project. There are a number of similarities between them, and certainly he's enormously impressed me with asynchronous conversations, and there is a place for that within the Civil Money Claims project. Equally, I'm not sure that the solutions that we find in the civil field will translate into the family field, where the parameters are entirely different. So the idea that there is one approach to the training and the equipping of the judiciary for the future must, I suspect, be flawed. The second problem we have at the moment in terms of researching and teaching the judiciary is that it's an evolving animal. We don't know what the final design will look like. At the moment, the Civil Money Claims Project are beginning to think, to research and to develop their next phase of the project. There isn't an overarching blueprint beyond the Briggs report, which will tell us what this is going to look like. So for those who are researching or thinking about training, it's a movable object and a movable feast. At the moment, a lot of the work that is online is what's known as the minimum viable product. This, I have to say, worries me, because I can understand that the court want to produce something that works. I am interested in the support that it can give to the litigant in person, so that they click on the word witness statement and they get a little video that says this is what a witness statement is, and they get a template and they can fill out what a witness statement is, that starts debunking some of the arcane language that is attached to the processes that we adopt at the moment. Now, that is not part of a minimum viable product. How much money is going to be available, how much time is going to be available to add all these developments in the future? I'm sure that they will be done, he says, looking at the head of the Civil Money Claims Project. But in terms of trying to work out what training we're going to be giving the judges, we're dealing with a movable feast, as I say. Another parameter, which I'm not sure the judiciary have taken on board to its fullest extent yet, is that we have been told that in this country, justice will be delivered from a much reduced court estate. It's all very well to say to somebody, come to court, but if that means deliver your kids to school at 9 o'clock and get to a court 100 miles away, the decisions we make may be very different in future. And there may be a move, because the judges want it, to a more remote way of dealing with matters, to deciding certain aspects of the case on paper and reducing and refining the actual inter-reaction with the clients, because there simply won't be the court estate which allows us to do that. Changed processes. I touched on issue refinement at the start of the process. I think Richard Susskind put it beautifully. Ask 20 questions to turn a mess into a problem. And that is, of course, what decision trees will be doing. I say that if you ask 5 more questions, you can turn the mess into a problem, into a legal problem. And that will allow the judges to see something which is perhaps more refined than some of the work that we get at the moment. One of the things which I particularly was impressed by the work that's being done by John in the Social Security Tribunal is the use of asynchronous conversations. It seems to me that it's a very worrying concept that we put somebody in court, we ask them questions, and we seek an instantaneous, ill-considered response. How much better is it to actually manage an asynchronous conversation, which may not demand an immediate response? It may allow the party 24 hours to answer the question, when they can actually think about that and come up with what their considered response is. They will have asked everybody else down the dog and duck already, but that's the way of the world. So another change to the way in which the judges are going to be working. As I say, we may not have set-piece hearings in the future. We may be moving to hearings in a more remote way. Now, just because we're living in a new environment, just because we're on the edge of a revolution, doesn't mean to say that everything that we've learnt so far goes out of the window. But what does concern me is considering best practice for ensuring that litigants in person are empowered and comfortable in a digital age. I've done some of the very early testing with video hearings. I'm always worried that I look like Judge Judy or something like that. Some of you may say there's no fear of that, but you get the idea. I am just a face on a screen, and a lot of people will understand that as Judge Rinder or Judge Judy. How do we bridge the gulf that is created by that flat screen? How do we make the connections which you can make in court, and I know it, in a more remote system? How do we maintain the authority of the court? If somebody walks into a courtroom, they're in a very alien environment. They know they are in something out of the ordinary. There is a certain gravitas to that situation. How are we going to be able to maintain that gravitas in a digital world? How are we going to police the court? I was talking to Joshua over lunch, and he was making the point that when he observed one of the tribunal hearings, the judge had to ask who else was in the room. Now, on one occasion, unbeknown to everybody else, there was somebody else in the room. That's fine where one of the parties is an institutional party. But what about when you have two litigants in person who may not be paid by the Marquis of Queensberry rules? What techniques are we going to have to learn in order to police the court? Maintaining open justice. How are we going to achieve that? And one of the things I've been saying today is that everybody thinks that open justice is the public being able to see the court. There is another side to this, which is that those in the court need to know who is also viewing them. If it is the woman who has already got an injunction out or a restraining order out, and the perpetrator goes into a booth and starts gathering information, how is she going to know that? The commercial competitor who wants to understand the business model of the other party. So issues that we have to consider. Overall, what I'm suggesting is that we don't throw the baby out with the bathwater, and that the days when we're going to remove a child from a family or a person's house remotely are, I think, a long way off. It has to be a blended system. And one of the other aspects that I think we have to be very careful about is the commoditisation of justice. As I say here, litigants in person sometimes want to tell a story as a cathartic experience. And it was very interesting listening to Tom's comments this morning about how much the litigants invest in the process as opposed to the outcome. So, you're all the researchers. What do we need to know? We're going to need to know how the new system works for the users. There's very little experience at the moment about what people want and what people don't want from a system. Who is being excluded and what's being done to address this? There is some work being done, but I don't know of any work upon cultural aspects. The idea that people can rock up to a CAB and get some answer may not necessarily work in some of the cultural communities that are spread around my particular court. And there are also gender issues. In some societies, it is not acceptable for women to have electronic devices such as phones or computers. And so I think we need to focus on the cultural aspects. Does the system work for the judiciary? Here we go, head in the lion's mouth. You love the idea of data. You want more data. You want the court service to capture every single byte possible. But for every byte they capture, they are keeping information about me. We are investing the state with a considerable amount of power in an age when I'm learning that people cynically misuse power. And Judith this morning was talking about judges being shown to be biased. Well, you get the information out of the system. Who is getting the information out of the system? What are the constitutional considerations that arise from that? So it may work for you, it may not work for me. Just finishing off then with the Judicial College I saw the first time. Do we need a Director of Digital Studies? We probably do. And we probably ought to be thinking about that now. Traditionally, the Judicial College has worked from judges deciding how to deliver judging. I am not sure that in a digital world that is an entirely sustainable model, because frankly, few of us have enough experience to be able to decide what work needs to be done, but more importantly, what research ought to be informing that. And so in the circumstances, we are going to have to deliver training. I make a plea that training is a continuous experience. It is not once or twice a year, which is what the judges are getting at the moment. It is probably going to be little and often, and it will be remote as well as face-to-face. Sorry, I'm 2 minutes over.
Chris, just 2 points on that. In terms of performance monitoring of judges and outcomes data, one, there are already private companies who are claiming to analyse data from civil courts to provide advocates with the information they need regarding which judge they should take a particular case beforehand. Now, so if we're concerned about the research community having access to that, we should be really concerned about private companies having access to that and using that to gain unfair advantage for parties who are better resourced. There's also the issue on the immigration side. The Ministry of Justice just released previously unreported decisions from the Immigration Tribunal. There are now, last time I checked, there are over 16,000 of them. You can filter those decisions by judge. You can filter them by party of origin, by country of origin of the parties, and it wouldn't take too much effort for someone who is interested to be able to build some sort of, to identify patterns in decision making. So I think in terms of that as an argument, not for building in data collection to the court service, I think the data's already there and being...
That was not my point. My point was that the data is being held by the state, and that we need to be thinking about what ethical considerations arise out of the holding of that data. Can they sell that data?
Yeah.
What uses can that data be put to? It would be like King Canute trying to stop the waves, to say, don't collect the data. And frankly, I'd rather the academic community has that data, because they might use it appropriately, as opposed to a commercial organisation have that data. But the point is this, that I don't think that we've given much thought to the ethical considerations that arise out of the fact that the state has the control over that data.
Thank you, it's a great point. And just drawing together some of the threads across the presentation. So I think what we heard is that the demands on judges and professionals differ from jurisdiction to jurisdiction area of law, as does the risk in terms of alternativization differ from jurisdiction to jurisdiction. In civil money claims, there's a high risk of private alternatives springing up, arguably less so in cases such as John's Tribunal, where one party is the state, although I'm sure we can imagine a dystopian future where that is no longer the case. And there's a wider question about whether you can combine cost reduction with increased access in a system where the decision maker remains judicial. I know Shannon's tribunal has hired a lot more tribunal judges, and that's worth thinking about in the context of the reform programme as a whole. Like, is there going to come a point where there's not the money there to hire judges, so we end up hiring someone else to do that? And there's also the really important point that Chris made and others about asynchronous processes, identity verification, and the incursion of undue influence on litigants in these proceedings. So those are just my sort of starters for reflections on the panel, but I'm sure there are lots of questions. Please.
So I have a couple of quick questions. One, to follow up on the data collection aspect. As you know from my presentation, that's sort of my bailiwick. But I think the other thing to consider is not only who has it, but in what form it's being collected. And there would be an enormous advantage to having someone with actual research experience and interface with your research community to come in and say, this is the way it needs to look if you want to actually be able to usefully analyze what's happening in the system for the good. So I have two quick questions. One's a general one for all of you, and one's a specific one for Shannon. So on your question about data and private companies, if I heard you correctly yesterday, Google Analytics is your interface. So my question for you is sort of what you all have done to make yourselves comfortable that because Google Analytics is a very powerful private entity, that you're protecting the data that you need to under those contexts. And then my other broader question is in terms of the cost saving for the system. I've heard a lot about open access, but is there going to be a shift and change in the actual economic cost, the filing fee cost associated with all of these various levels? Is it going to be less expensive or more expensive, or do we not know for the user?
Can I answer your last question? Because it is one of the biggest bugbears of the Civil Money Claims Project at the moment, which is because we haven't got legislation that was promised to us 2 or 3 years ago, we are now having to work within the civil justice system. And that means that we have to work within the civil justice fees system, which is producing some extraordinary anomalies. You can get a judgment for free, but if you come to a settlement and that breaks down and you have to then get your judgment, it costs you £250. I don't think, speaking personally, that the present fee structure is defensible in a digital age, because notionally it's based on what it costs the court service to actually produce the answer. Now, if we are going to reduce the overhead running costs, I can't see how the fee structure can remain the same. It just doesn't match the new online processes.
Jump in on both questions briefly, if that's okay. For us, our budget is set by Treasury Board. We're a public institution. We do have fees because they have a deterrent effect and they help defer the cost, but it's not cost recovery. That said, taking out the small claims cases that we have from the court system has reduced their caseload by 40% and is projected to free up $2.5 million in the court system that can be diverted to reducing criminal and family trials. So I think that we do that while increasing service to people. And the way we do that is that almost all of my staff and tribunal members work remotely. The sum total of my commercial real estate in downtown Vancouver, which is expensive, is about half the size of this room. So almost all of our budget goes to staff salaries who are on the phone with that 80-year-old I mentioned yesterday, and it's all frontline services. My remote working staff have a cell phone and a laptop and a monitor. And I can tell you incidentally that allowing them to work remotely, in fact requiring them to work remotely, and using their performance rather than the number of hours I see them sitting in a chair as a metrics of performance, has resulted in being able to recruit and retain tribunal members and staff who easily could make significantly more money in the private sector who choose to work for us because it makes their life work. So particularly, I have brilliant female lawyers who may have small children and don't want to commute downtown every day, need the flexibility to go off to a preschool play, and all of that, I think, all of the services and brilliance and commitment that they bring to the table, as well as their approach, I think really has increased services to people and allocate taxpayers' money where it really is usefully spent. That's the answer to your second question, but I've gone on too long, so I'll let the others have a chance at that one first.
Well, as far as our training is concerned, it's free, and I don't imagine that would change.
Just as a last point, I fully agree with the fee argument. It's indefensible that first you get money to invest in reducing cost, and then not giving that cost, translating that cost somehow in either a change of the fee structure that really reflects the kind of procedure that you're now offering, or giving it back to the taxpayer. But that is a debate that is ongoing in the Netherlands, and as far as I can see, it's not going anywhere.
Because you lost the Rechtwijzer through lack of funding, didn't you?
Yeah, well, that's Rechtwijzer is actually, it is a private enterprise, so it's not a government service.
Oh, I see.
So that the dynamics there are very different. But there is a new startup for a commercially viable Rechtwijzer that, from what I hear, is going fairly smooth.
Well, I read the report that Joshua directed us to on early progress in transforming courts and tribunals, which describes a lot of the work here is driven by efforts to limit the real estate, sell some of it, get the profits. It doesn't talk much about returning it, but actually mostly about downsizing, and talks about the retooling is driven a lot by cost constraints and those efforts. So I wanted to sort of follow up on the questions that were asked about both. One question is, how is the decision about which courts are closing here determined? So from across the ocean, when you hear the word Her Majesty's courts, you think actually that it's judges who are Her Majesty's courts, but I just used earlier this interpretation of what would have been thought to be plain language. So in this, at least one version of the drivers of this on the repeat players are governments seeking to reduce government services of all kinds and recoup costs not necessarily go to more communal activities, which interacts with the remoteness question. Because law schools are also moving to lots of people away, and we see it as a cost to community, to interaction among co-decision makers or teachers or students or judges in their isolation. And so the question about how in this, how much the virtual toolings will find ways to generate alternative forms of community and return to the resources. And the related question is about, which came back to, you said Google Analytics, and of course I think it's called Cambridge Analytics. But but the point of hacking control and information, which was raised by who's going to buy and what the material is used for, Bentham looks innocent, so does Zuckerberg, so do we all, about the cheery versions of all of this, and where are the ways in which we all have to worry about the lights going off, let alone the hackers. So those are related to the money questions and the decisional authority questions.
Natalie, can I answer 2 or 3 of those? Start with the last one. The data ethics, which Chris rightly raises, are hugely important in this debate. I absolutely accept that. And the way in which the data will be collected on behalf of the state, not on behalf of the judiciary, but the state generally, is of great significance. The Nuffield regards it as sufficiently significant that its adventures into the ethics of data will be its next big project. And so at a conference not too long from here, in a place somewhere near here, we'll be talking about that next, because we see that as something we want to hear from you about, and our collaborators in the United Kingdom and across Europe who would want to join with in that debate. Now to turn to the difficult bits. The difficult bits are that in England and Wales, not in the United Kingdom, Scotland is different, Northern Ireland is different, but in England and Wales, the court estate is controlled entirely by the Lord Chancellor and the Secretary of State for Justice. It is not controlled by HMCTS. They have only recently inherited its operational running and its maintenance with a budget to go with it, which is set by the Lord Chancellor. So judges do not close courts, they don't open them, save for withdrawing plaques in the public domain without names on, and we are constituents just like the public in responding to consultations about closure and the effect upon real people of those closures. And 2 of us, that is myself and the Chief, are even ring-fenced from the board discussions about that, because the board discussions come to us as a recommendation. We can't veto them, but we then comment upon those recommendations before they go to ministers, and ministers alone decide on the closures. The context of that is important, because what I'm going to read to you now is the only sentence that is official and approved by those ministers. And it says, the price for the investment, that is the £1 billion reform in the reform programme, is a requirement for long-term spending reductions. The aim is to reduce annual costs by approximately £250 million by 2022. Without that reduction in cost, let me interpolate, the system would not be able to continue to run. So that is the basis upon which the Chief Justice has agreed to that back in 2014-15. So we reduce 250 million from a current cost base of 1.6 billion per annum. Approximately 16,500 court officers will reduce to just over 10,000. That number is the constant source of negotiation and debate, but that was the original ambition. The 460 buildings that then made up the court estate in England and Wales would be reduced, first of all, to 350. Well, that's just about happened, with more reductions due to come. So the phase that we're about to enter into, consultations closed, Recommendations are about to be made for a small number of courts. We'll reduce the number again. And I can predict as night follows day that there'll be another phase that will lead to court reduction. And so the scale of the estate, as Chris has rightly commented upon, will fundamentally change as the way we deliver justice fundamentally changes. That's not the judiciary decision. I'm very happy to collaborate with government and the legislature to deliver access to justice to safeguard the rule of law. But I have to find ways of doing that within the budget that is given to me, and that is negotiated on an annual basis with the Secretary of State, with the Treasury standing behind that, and ultimately the Prime Minister behind that. And if you have a government that needs to depend upon slender majorities and political risk aversion, then those negotiations, as they are today and yesterday, at 8 o'clock this morning, at 11 o'clock last night, interesting.
I want to say something about local justice and local courts for the most vulnerable members of our communities here in England, and how there are many unintended consequences of the closure of local courts. An example would be, for instance, the closure of local courts surrounding the Greater Manchester area, and on the basis that all of those customers can come into the brand new, magnificent, huge court building in the centre of the city, driving more and more women in the Pakistani and Bangladeshi communities that surround Manchester to use the Sharia courts, which they're already under great pressure often from their families to use. That may have been a consequence that the government took fully into account, or it may not. It is, as Harold Macmillan said in another context, like selling the family silver. If we sell off all of our local courts, our most vulnerable communities, and many of them also are ethnic minority communities, will suffer the most. And it is a very, very short-sighted thing to do. When every time a family experiences that good experience of trusting the process, even if the decision doesn't go their way, it's remarkable how they trust that process, then their families know about it, their neighbors know about it, and you are strengthening the warp of the social fabric every time that happens, and it should happen in their communities.
Could I make an observation which is really coming from the civil JEG, which is that you paint a very stark picture of the present provision of courts, or a much reduced provision of courts, and you rightly point to the social consequences of that. I think it is accepted that there are some processes that you simply cannot do remotely, certainly in the foreseeable future. I think childcare is one. Another one is housing. Taking away somebody's house is a process that quite often needs a face-to-face hearing, because quite often you can solve the problem with the party actually there. And so there is provision in the thinking, as far as I'm aware, for temporary courts. I hate the term pop-up courts, but it's the one which is sometimes used. And there certainly have been examples of trials of that. There was a trial of a housing court in Tunbridge Wells, in the council chamber at Tunbridge Wells, and in fact I believe that's still going on. There was another trial using part of Aberystwyth University estate in order to provide accommodation for a court there. It's not ideal, and I personally have some reservations about holding a housing court in the premises of one of the parties where the local authority is seeking to manage its own housing stock. But I'm not sure that the choice is perhaps quite as stark as you were painting it in what you were just saying.
Can I just, unless there's some question. One issue that has arisen is this question that Christopher raised about gravitas. How do you run a court if you're doing this remotely? If your parties on their smartphones, how do you persuade them that you're in a position of authority without the wigs and the dais and the Latin and the buildings and the court clerks and all of that stuff? And I think it does require a different skill set, and it is one that we do train our tribunal members in. How do you maintain decorum in a telephone hearing where people are trying to talk over each other? How do you have the skills to ascertain if there are other people in the room? How do you swear people in remotely? How do you make sure that they respect your authority? And I think it is a bit of a fiction that we have. The source of our authority as judges and tribunal members comes from all of those artifacts. I think we are very attached to those artifacts in the legal profession, but I don't think the public is in the same way. And I think, in fact, a lot of those artifacts operate to distance us from the public. People find them intimidating. They find the robes intimidating. They find the Latin intimidating. They find the dais intimidating, the bowing, the my ladies, all of those things that we really hold on to as artifacts. I think we should question what purpose they serve for the public. And I have never had a problem commanding respect in a hearing despite wearing a suit or being on video cameras, because it's a matter of how you treat the parties and how they treat you, and the fact that you have the power of contempt powers backing you up. And that doesn't change depending on your robe. I've never had to resort to that either. So I think I would just caution us not to take an evidence-based approach about these artifacts and to question.
I don't permit my judges to wear robes for that very reason. The sort of decision-making that they are making is such that it would be inappropriate to reinvent Victorian adjectival baubles in order to create respect. You may need them in other circumstances, I don't doubt that for a moment. I'm thinking particularly of Australian judges who died because their anonymity wasn't respected. So you do have to be very, very careful about generalisations. But in the fields that my 6,000 judges sit in, we don't wear robes except to swear them in once or twice a year, and that is it. And just to add one interesting thing, you've been talking about cultural competency training. You've been touching on it in a number of different ways. The Max Planck in Berlin is doing a major conference later this year, which we're participating in with the English and Welsh judiciary on just that aspect. So some of the things that Martha was talking about there, which are hugely important to us, what are the unintended consequences that we should be thinking about in and out of the course of tribunals. The Max Planck, bless them, are taking that on, and we're going to have a good discussion about that.
Leslie, could I come back to something Ernest just said, and which struck me also in all the presentations this morning? I think there's more to the court cost problem than just an incident. I think it's a tendency that's been going on for a long time. I don't think it will go away. So, Ernest, you announced now the court estate has gone down from 450 to 350. It will keep doing that.
Yes.
And I find that very worrisome.
I mean, that
I have no answer to it. It's a reduction of the public sphere across the board, and it's not going to go away. And I have no answer, but it really worries me.
I mean, I think at some stage, and I'm not going to predict when, there comes a point at which we say no, and then we leave the problem where it properly resides, which is with politicians who are responsible for the policy and the ultimate budget to the Treasury. But at least the court justices have said when they mean it. And the other aspect is that the substitute accommodation has got to be serious. I actually have 60 hearing rooms in hospitals. I'd quite like to have 100 hearing rooms for every major local authority area in Britain that are domestic to those local authority areas without being in conflict so that I'm using one party's accommodation when it's inappropriate. Those are very real things that I'd like to be able to investigate. There's even a policy in central government which is supposed to make available public buildings for multiple purposes. I'd quite like to actually put that on the line and use it.
Can I just mention something to do?
Yeah.
Can I just mention something to do with rules? Just an alternative view. It's not to you in my view, but it's the same jurisdiction in the US that's deciding on benefits, disability benefits, the Social Security Administration, and they do video hearings. as part of the video hearing, they really do dress up the stage, if you like. The judge appears on the TV screen, but is wearing robes, has a crest, it's blue, yes, exactly the same issue. And when I asked them about that, because that's completely opposite to what we do, it was a pretty sensible answer, I thought, and it was that they felt that the appellants needed to know that they had been through the administrative system, and now they were in the judicial system, and they should see that this was the judicial system that they were from.
Can I just say that was exactly the point I was going to make. I'm not a great fan of reps particularly, but there is a balance between formality and informality. And we were speaking this morning about trust and confidence and respecting the decision maker. And the party that you have to convince, who has to go away feeling that this decision was acceptable, is the losing party. That, for me, is the object. That's the person we need to be thinking about, the person who just lost the case. And my concern or my interest is when you're doing it on a laptop. If I'm sitting in my kitchen and this face pops up on a laptop and I lose, how do I feel about that? What makes me sense the authority, respect the decision? Now, it isn't just what they're wearing, but there's something about demeanour and how that's dealt with and all those things that I think have to be translated into an online process. And actually having somebody sitting with the independent crest indicating that it is independent and judicial might not necessarily be a bad thing. You don't want to terrorise people, so there's a balance between terrorising.
And when I mentioned the Social Security Administration judges, appeal judges, they generally don't represent people, even on video, they're genuinely represented because they pay people out of the on a known fee. So they are quite often represented.
Can I just allow Arlette to come in and then we'll Brexit?
Yeah, so I want to ring my bell, the user interface and what actually determines trust and legitimacy once we conduct the process on an online interface. And what we need to consider on top of the institutional legitimacy and legitimacy of judges and how we generate trust is that we have a lot of research in this field about the indicators or what actually predicts trust on websites, and it's a lot less than what we're talking about here. So the color palette, how much content there is on the landing page, where the buttons are located, how easy it is to find the first task that you need to do on the landing page. That has a lot more to do than anything else that happens.
Have they tested that out with a judge wearing a tracksuit?
and I should say that these judgments, they're so tricky because they take milliseconds to happen. And when you test that and give people 15 milliseconds or a second or a minute, it doesn't really change. So those predictors they operate so quickly. And so when we're thinking about designing those environments, we have to take into account that the judgment is done based on these heuristics that are very, very quick. And of course, later on, as the process comes in, there's going to happen, a lot more is going to happen. But it's a different game, and we need to take that into account. And I also want to pick up on Dory's point about the shrinking public sphere. And again, maybe pick up also on Jim's point earlier today, compared to what? What public sphere in those over 90% of cases that are either not allocated to a judge or never get to see a judge or never get into the courtroom. And so what happens if we take those cases, even if some that are privatized into different systems but are getting a different product, or are going through the judicial system but are getting a lot less compared to the in-person hearing standards, but a lot more compared to what they're actually getting today, which is probably being dismissed earlier in the phase or being settled without any judicial or institutional intervention. So perhaps we can actually increase the public sphere by offering something that is digitalized or even automated, but is designed with public input and guided by public values. And so I think it's not as clear-cut to say that we're shrinking the public sphere by.
I don't think we are shrinking the public sphere, but it's shrinking. The politicians are doing it. But anyway, statistics from my court system do not confirm what you say. We now process about 3 times as many cases as we did 15 years ago with the same number of judges. Processing in terms of putting cases, of dealing with cases that come to the court and need to be decided on. There is a slight shift in how we deal with them, but it's not as dramatic as you suggest. I think about at least half the people who file their case in court actually get to see a judge. My data don't confirm what you say. No.
Thank you so much to the panel for giving me your time. That was a really, really interesting discussion and really interesting presentation. Thank you so much.